Good afternoon and a very warm welcome to you all today. For those of you who don't know me, I'm Juliet Bain and I'm a partner and the head of pensions at Brodies LLP. I'm joined today by two of my senior associates, Maureen Burns and Jane Foley. We're delighted to have so many of you with us today. Obviously, GMP equalisation is a huge topic, hence why we've chosen to focus on a specific aspect of it, namely the key tax issues arising from GMP equalisation. But this is, of course, a highly technical area. We can't possibly cover everything in the time that we've got today, and I suspect we'd probably drive you all potty if we tried to do that. But we were keen to share some of the key points that we're seeing from a legal perspective. Format-wise, as it says on the slide, we're going to give a bit of an overview of the background to set the scene. We do have a very knowledgeable audience today, so we're not going to overly labour this section, and we'll then get straight into the tax points that we are going to cover, which are annual allowance and the impact on the deferred member carve-out, the loss of lifetime allowance protection, and revisiting past benefit valuations, followed by some final closing thoughts and a wee Q&A. We will refer to a number of guidance notes, team updates and blogs throughout the presentation. Links to all of these are at the end of the slide deck, which, as I say, we will share afterwards. Now, I am, of course, aware that a wee thing was published at the end of last week relating to GMP equalisation, and that this is no doubt on the minds of most, if not all of you. That, of course, being the long-awaited judgment in the third Lloyds Banking Group case. We're not going to focus on that, sorry to disappoint, in our presentation today, because it doesn't squarely fall into our focus on tax issues. But we did publish a blog on the judgment yesterday. As I say, the link to that will be at the back of the slides. It's also on our website, and we're happy to touch on it in the Q&A if we have time. If there is anyone who missed the key outcome from the case, the judge confirmed that trustees will have to revisit pension transfers spanning the last 30 years if the individual had contracted out benefits and provide a top-up if necessary. It makes it clear that members are entitled to a top-up payment in these circumstances, although it does seem that there's a bit of leeway for trustees to agree an alternative solution with members. So it's a major decision with potentially huge ramifications for some schemes and for the task that will need to be undertaken by trustees. Okay, so back to today, I will now hand over to Jane, who's going to provide some brief background. Jane.
Thanks, Juliet. Well, to do justice to the complex journey GMPs have been on over the last 2 decades to reach the point that we're at today, well, it would clearly take more time than we've got. But we've set out some key milestones of that journey on this first slide, and I'm going to give a brief summary just to put into context the tax issues that we're going to focus on today. Now, if anyone does have any questions or wants more detail on the history of GMPs, please do feel free to get in touch after the webinar. So GMPs weren't included in the swathes of equalisation exercises that followed the Barber judgment in 1990, because it wasn't clear whether GMPs were pay under EU legislation. And even if they were, how on earth should schemes go about equalising for GMPs? GMPs are by their nature unequal. They usually accrue more quickly for women than men, and usually the GMP element of total pension will be higher for a woman than a man, with the corresponding excess for a woman being lower. Now, broadly, these differences mean that the total pensions are likely to grow on an unequal basis over time, due to the way in which each element is increased. So over the last decade or so, the consideration of GMPs and equalisation has ramped up a gear, with the introduction of the conversion option to the GMP legislation and the DWP looking at various equalisation methods in its consultations in 2012 and 2016. But it wasn't until the 2018 High Court decision in the Lloyds Banking Group case that the issue of whether and how schemes should equalise benefits for the unequal effect of GMPs was finally properly addressed. So what did the Lloyds judgment say? Well, the High Court decision in Lloyds made it clear that benefits in excess of GMP must be adjusted so that the total benefits received by equivalent male and female members are equal. 4 methods, some of which were split into sub-methods, were considered by the court in Lloyds, and these largely represent the range of options that are generally accepted within the pensions industry to be available for equalising for GMPs. At one end of that spectrum, Method A envisaged identifying each inequality separately and then giving members the better alternative. And at the other end of the spectrum, Method D involved offsetting all advantages and disadvantages to arrive at a net position. So just looking at them all very briefly, Method B provides the better of male or female comparator pensions each year. Sub-method C1 uses the same basis as Method B, but it's subject to accumulated offsetting. Sub-method C2 is essentially C1, but makes an allowance for interest on the required adjustments. Method D involves undertaking a one-off calculation of actuarial equivalence, where the actuary determines the higher of the actuarial equivalence of the unequalised female and male pensions. Sub-methods D1 and D2 both involve a one-off assessment of actuarial equivalence, but D2 involves GMP conversion after the one-off equalisation calculation has been made. So the dual records approaches, as they're commonly referred to, methods B and C, were both held by the court to be permissible ways of achieving equal treatment, whilst the other dual records approach, method A, was not permissible, and that was due to the minimum interference principle. Now, this principle also meant that the employers in Lloyds could require the trustees to adopt sub-method C2. Sub-method D2, or the conversion method as it's commonly referred to, was held in principle to be a lawful method of equalisation. A second hearing in December 2018 helpfully confirmed that if trustees do opt for D2, they don't need to use C2 to equalise benefits as a first step. So the judgment was helpful in confirming that schemes must equalise for the effects of GMP and in setting out some possible methods to achieve this. But as you'll all be aware, there are clearly outstanding questions from the Lloyds judgment, and many of those outstanding questions relate to addressing the tax issues when schemes actually start looking at how to apply their chosen methodology. So what guidance is available? Well, we've set out on the next slide the various guidance that has become available since the Lloyds judgment, and which many schemes waited for before considering how to equalise for GMPs. I'm not going to go into these in detail, they're set out on the slide there, but just to say it's the HMRC guidance set out on the slide that we'll be focusing on today. Now, turning briefly to look at the various considerations for schemes when looking at the best available methodology for them to adopt: dual records, methods B or C, or conversion, method D2. It's clear that the decision is very much a scheme-specific one, and in some cases it will be a member-specific one, as the same approach doesn't need to be adopted for all members. There's no one-size-fits-all approach. But that said, there are some generally accepted pros and cons applying across the board, and we've set these out in the table on this slide. Now, some key points just to draw out from the table. I'm not going to go through it in detail, but some key points to draw out are that with dual records, the GMP and associated inflexibilities remain. For example, the inability to draw a GMP before reaching GMP pensionable age. Whereas with conversion, the GMP goes away, and that includes the legislative restrictions and any complex anti-franking issues, allowing greater member flexibility. Dual records is administratively complex, and there's clearly room for error. And although the position seems to be gradually shifting towards a more flexible approach, it's really not surprising that the insurance industry initially took a very hard approach to dual records, in that it was difficult, if not impossible, for schemes to find an insurer willing to take on schemes adopting a dual records methodology. With conversion, the long-term administration is much simpler, with no ongoing checking to be done going forward. Now, these are clearly all factors pointing towards conversion being a much easier, simpler option. And even the employer consent that we've set out on the slide shouldn't be a problem using the conversion method, as the employer and trustees should be working together on achieving a solution to equalisation. But the tax issues do present a major headache, and it's the final issue on the table to which we'll turn now and look at some of the challenges facing schemes from a tax perspective. Now, I'm hoping that I've struck the balance there between losing you to thoughts of your Christmas shopping and giving some useful background to how we got here. And on that note, I'll now hand over to Maureen, who's going to focus on the first two issues on this slide: the annual allowance and the deferred member carve-out, and the loss of lifetime allowance protections. I'll then come back in briefly to touch on the practical issues we've encountered in advising on revisiting past benefit valuations. Maureen.
Thanks, Jane. I was so anxious to speak there. Hi, everyone. Well, following the Lloyds Banking Group case, as most of you will be aware, there were concerns within the industry that GMP equalisation benefit adjustments would potentially constitute new accrual of benefit that would have to be tested for annual allowance purposes, or which would prejudice lifetime allowance protections. Helpfully, HMRC guidance issued in February 2020 confirmed that an increase in the amount of pension due at retirement is not a new entitlement, as it results from membership of a pension scheme in the period between 17 May 1990 and 5th April 1997, which, as most of you will know, is referred to as the Barber window. Therefore, in the main, where a dual record-keeping approach is taken, such GMP adjustments on their own would not constitute new accrual of benefit that would have to be tested for annual allowance purposes, or which would prejudice applicable lifetime allowance protections. Unhelpfully, the guidance also confirmed that for pension schemes using the conversion method, there may be consequences for scheme members if this method is applied. For example, converted benefits through a higher revaluation or higher rates of pension, which may result in either the loss of deferred member carve-out or fixed protection, or both. Whilst HMRC has confirmed that it is continuing to explore the tax implications for schemes choosing to use conversion, as most of you will know, there has been no indication when this further guidance will be issued. And in our recent experience, for schemes that are equalising through conversion, these uncertainties remain the largest stumbling block. And so we thought it would be useful just to outline our experience of dealing with these issues in relation to DB schemes. So, what is the deferred member carve-out? Well, in very broad terms, as you will know, under the current pension tax regime, the annual allowance is the maximum amount of pension savings that an individual can make in a registered pension scheme in each pension input period, with the benefit of tax relief. Where that allowance is exceeded, the individual will pay a tax charge on the amount over the annual allowance. There are certain situations where part or all of an individual's pension savings will not be liable for the annual allowance, including where the individual is a deferred member of a DB arrangement, provided their benefits are not revalued in excess of a specified limit, which is intended to allow for scheme and statutory deferred pension increases. In those circumstances, the member would be treated as having no pension input amount during the pension input period, provided the increases are within the permitted amount under legislation. And this is what's referred to as the deferred member carve-out. Now, for the purposes of today's discussion, I'm not going to go into the detail of the permitted amount. However, I thought it might be useful just to summarise the position for a deferred member of a DB scheme on the slide. Broadly, increases will be within the permitted amount, provided they do not exceed the relevant percentage plus the relevant statutory increase percentage. So now looking at the issue, what is the issue? Well, a right to GMPs not taken into account for the purposes of the deferred member carve-out, and so the rate of increase that must be given on a GMP can be ignored. Converting the GMP into a non-GMP scheme benefit would mean that increases in respect of the converted benefits would have to be taken into account for this purpose, and there's a risk that the rate of increase on the converted benefits could be in excess of the amount permitted by legislation, i.e. the relevant percentage plus the relevant statutory increase percentage, meaning that the deferred member carve-out would be lost, and changes over the pension input period in the member's entitlement may use up annual allowance and result in a tax charge if the annual allowance is exceeded as a result. The issue in a nutshell is how to avoid creating increased exposure to the annual allowance charge for the members and any resulting member complaints, adverse publicity, and of course reputational damage. So, what's the solution? Well, it's a difficult issue which many firms and schemes are grappling with, and based on our experience, there is no obvious or risk-free solution. The potential risk exposure will be to a large extent scheme-specific. It will depend on the shape or form of the converted benefits, the scheme revaluation provisions at the relevant time, and the applicable legislation. And so to reiterate what Jane said earlier, there is unfortunately no one-size-fits-all approach. To give an example, if a minimal interference approach is taken and fixed rate revaluation is included in the post-converted benefits, then conversion is likely to take it outside the deferred member carve-out. If the fixed rate revaluation is not included post-conversion, the deferred pension may need to increase in order to maintain actuarial equivalence, which is a requirement of conversion. And this increase is also unlikely to be covered by the deferred member carve-out. Regardless of which approach is taken, we would stress that it is vital that this issue is considered at the early stages of the project to enable sufficient time for actuarial and legal advice to be taken on the options available to trustees. So what are the options? Well, if there's no immediate pressure to complete GMP equalisation, then it may simply be preferable to adopt a wait and see approach until there is greater clarity from HMRC on the potential tax implications. However, as I mentioned earlier, it's not clear when or indeed if HMRC intends to issue further guidance, and so this may not be attractive or indeed possible for schemes that want or need to complete their GMP equalisation project. An example of this would be for schemes seeking to complete a buyout, where conversion is the only method that the insurer is willing and able to support. And this has certainly been the case in some of the schemes that we've been working with, where it's been necessary to find solutions to enable trustees, in conjunction with the sponsoring employer, to reach a view that the benefit of risk transfer in the buyout arguably outweighs the risks involved with this approach. Obviously, in that scenario, the decision would be a commercial one, and trustees would have to be satisfied that they would be adequately protected from the risk of future claims through insurance or indemnification from the sponsoring employer. And this is a challenge in itself, as how do you quantify the risk? And who's responsible for doing that? Is this a concern for trustees? Is this a concern for sponsoring employers? Depending on the terms of the bulk annuity contract, it's also likely that agreement from the insurer will be required. Now, this issue is well understood in the industry, and in our experience, and depending on the level of risk in specific circumstances, insurers may be willing to work with schemes to reach an acceptable position to mitigate the risk. We are aware that more insurers do now have the ability to support a dual record keeping approach, And where this issue is considered a major area of exposure for the scheme, the insurer may be willing to agree to support a dual records approach for certain members, where this previously just wasn't an option. And this would remove a substantial element of the risk relating to this issue. It's undoubtedly difficult, and but there are solutions from a legal perspective, albeit that in the absence of further guidance from HMRC, none of these are risk-free. Now, on the basis that you are all still with me, I'll move on to the next issue that I'm going to discuss today, which is loss of lifetime allowance protection. Now, as I'm sure most or all of you will know, under the current tax regime, the lifetime allowance is the amount of pension benefits that a member can take from a UK registered pension scheme without incurring a tax charge, known as a lifetime allowance charge. The occasions where a member's pension benefits are tested against the lifetime allowance are set out in legislation and are known as benefit crystallisation events. When the lifetime allowance was introduced in 2006, individuals who had built up pension rights under the previous regime were given transitional protection from the lifetime allowance charge. And as subsequent reductions have been made to the lifetime allowance in 2012, 2014 and 2016, further forms of protection have been made available on each of those occasions for individuals affected by each reduction. There are 7 main forms of protection, and I'm sure you'll be relieved to know that I'm not going to go into the detail of each of these, but I thought it would be useful just to set these out on the slide for the purposes of this discussion and also for future reference. But as I mentioned earlier, there were concerns that GMP equalisation benefit adjustments would potentially constitute benefit accrual, which would result in loss of lifetime allowance protection. Therefore, for the purposes of this discussion, I'm going to focus on fixed protection and enhanced protection where further accrual is limited. So taking the first of these, fixed protection. The legislation is complex, but generally fixed protection would be lost where there is benefit accrual. As set out in the table, any increase beyond the relevant percentage would be classed as benefit accrual. The relevant percentage is separately defined in legislation for each of the fixed protections that are available, and the detail is summarised on the slide. So what's the issue? Well, as I mentioned earlier, helpfully the HMRC guidance confirmed that GMP equalisation benefit adjustments should simply reflect the benefits the member has accrued before 6 April 2006. Therefore, where a dual record keeping approach is taken, any increase solely for GMP equalisation will not be benefit accrual and so should not result in loss of fixed protection. This is because, like the deferred member carve-out, GMP equalisation benefit adjustments are attributable solely to the application of Section 67 Equality Act 2010. And so they're within the relevant statutory increase percentage element of relevant accrual. Unhelpfully, the HMRC guidance states that if the reason for accrual is a mixture of GMP equalisation and other adjustments, as may be the case for conversion, then fixed protection could be lost. As is the case with the deferred member carve-out, the potential risk exposure will be to a large extent scheme specific. Again, it will depend on the shape or form of the converted benefits and the increased provisions in the scheme rules at the relevant time, and specifically whether the converted benefits could be construed as introducing a different rate of increase. When considering the test for benefit accrual for any of the fixed protections, it's important to appreciate that this test is fundamentally different from the test for relevant benefit accrual for enhanced protection. So turning now to enhanced protection, a member may lose enhanced protection in several circumstances, including where there is relevant benefit accrual. The HMRC guidance states that for those who have been deferred members since before 6 April 2006, the GMP equalisation benefit adjustment should not be relevant benefit accrual. However, individuals who have not been deferred members since 6 April 2006 will have accrued benefits that, with GMP equalisation adjustments, may result in relevant benefit accrual. In a DB scheme, benefits may continue to accrue and contributions continue to be made after 5th April 2006, but if they accrue at more than a set rate known as the appropriate limit, the member may lose their enhanced protection. The detail of the appropriate limit is summarised on the slide, but it's broadly the greater of an indexed amount in revalued earnings. So what's the issue? Well, the HMRC guidance states that when carrying out the relevant accrual calculations, the value of the member's rights under the arrangement as at 5th April 2006 need to include the adjustment for GMP equalisation valued at that date. Unlike for fixed protection, there is no statutory increase percentage element of relevant benefit accrual, and so there's a risk that benefit uplifts resulting from equalisation and/or conversion may result in enhanced protection being lost. So far in the schemes that we've been working with, we've not identified anyone with enhanced protection, but depending on the individual circumstances of the member, this potentially presents a real issue for the member and also for the scheme. The emerging view appears to be that a change in the legislation on relevant benefit accrual would be needed to explicitly deal with the risk of enhanced protection being lost as a result of equalisation and/or conversion. However, as far as we're aware, HMRC has given no indication that the government plans to legislate to address these issues. It's not clear from the guidance the extent to which other forms of lifetime allowance protection would be affected by conversion. However, on the basis that further accrual of benefits is permitted for these forms of protection, it's unlikely that these issues would apply to those with primary protection and individual protection. So as most of you will be aware, losing lifetime allowance protection could potentially result in significant tax charges for the member, and these are summarised on the table. Given the potentially significant financial implications that loss of lifetime allowance protection could have for the member, in our experience, the risk of member complaints potentially represents the biggest area of exposure for trustees when equalising by conversion. The challenge here is, how do you identify members with lifetime allowance protection when this is not information typically held by a scheme? And so how do you quantify the risk? Well, the level of risk is not only scheme specific, but in many cases also specific to the individual member. And so in our experience, it's often necessary to consider individuals who have been identified as having some form of lifetime allowance protection on a case-by-case basis. Of course, in order to do that, it's necessary first to identify the members. But to assist with this, the correspondence issued to members as part of the communication and consultation exercise, which must be completed under the conversion legislation, should include a clear explanation of this issue and request that members with lifetime allowance protection contact the scheme as soon as possible. We would also suggest sending multiple follow-ups to tease out these members and just reduce the risk of unknown members with lifetime allowance protection subsequently making a claim. As with the deferred member carve-out, it might be preferable to adopt a wait-and-see approach or consider the possibility of temporarily excluding members with lifetime allowance protection from the conversion exercise until there is greater clarity from HMRC on this issue. Where this is not an option, then solutions to this issue can be found, which are acceptable from a legal perspective. But for the reasons that I've previously outlined, these are not risk-free, and trustees would have to be satisfied that they would be adequately protected from the risk of future claims through insurance or indemnification from the sponsoring employer. So in many cases, the solution will involve ways to mitigate the risk of future claims. Of course, where the scheme is in the process of buying out, the insurer would also have to be on board with any proposed solution. And as I've previously mentioned, depending on the level of risk involved, it may be possible to agree with the insurer to support a dual records approach for these members, where this was previously just not an option. Whilst this would significantly reduce the risks associated with this issue for those with fixed protection, there would be a residual risk in relation to future claims from any unidentified members with lifetime allowance protections, and also for those with enhanced protection. But how do you quantify that risk? Well, I'm sure you'll all be sick of the sound of my voice by now. So I'm going to have a sip of water, and I'm going to hand you back over to Jane to briefly run through the final point, revisiting past benefit valuations.
Thanks, Maureen. As Maureen said, I'm going to just do a very brief run through the practical implications of revisiting past benefit valuations, just to follow up on the issues that Maureen has covered. So the first point to stress here is that HMRC's February guidance applies when revisiting past benefit valuations, and that's whether you've adopted a dual records approach or the conversion methodology, because the focus here is on revisiting past benefit calculations for pensioner members, and the issues aren't affected by which equalisation method you've opted for. So what's the issue here? Well, GMP equalisation uplifts may have an impact on any past or future benefit crystallisation events. And just by way of a quick recap, as I'm sure you'll all be aware, but very broadly speaking, to put this in context, each time benefits are taken from a registered pension scheme, there's a test against the lifetime allowance to make sure a tax charge is applied if the lifetime allowance is exceeded. And the occasions when the test is carried out are called the benefit crystallisation events, or BCEs. Now, the February guidance from HMRC confirms that for a scheme's pensioner population, where a GMP equalisation uplift is applied, the BCE calculations already performed post 5th April 2006 will need to be reworked using the revised starting pension and the individual's remaining LTA at the time of the original BCE. Now, this could result in an LTA charge being triggered, and it could also have a knock-on impact for any later BCEs. HMRC makes it clear that it's for the scheme administrator to consider what process is appropriate to adopt in identifying whether any GMP equalisation adjustment to the member's benefit is likely to have resulted in a lifetime allowance charge. Now, it all sounds fairly straightforward in theory, but in practice, going through this process and achieving compliance can, in our experience, be very onerous, depending on the size of the scheme, the number of potentially affected members, and the available data, and in particular, the quality of the data available. And we've set out on the next slide some of the practical issues that we've encountered, which I'll briefly focus on now. So firstly, time and cost. Are the necessary resources and funds available to embark on this project? Well, schemes will need to consider whether they're able to resource checks on all past LTA calculations, or can they only do that where the difference is expected to be material or lead to an increased tax charge? And we found that deciding on the acceptable parameters can be difficult in these circumstances, and there's no guidance available to assist schemes in making this decision. Secondly, looking at whether all the necessary data is actually available for revising the calculations. As you'll appreciate, many schemes won't hold the details of the LTA that the member may have used in other pension arrangements, and they'll only be able to carry out checks in respect of members' benefits in their scheme. So next, looking at communication. Well, as Maureen touched on earlier in respect of the loss of the LTA protections, the risks of getting it wrong in not identifying potentially affected members can be mitigated by communicating with members and making inquiries as to any LTA protections or benefits in other arrangements which might have used up the LTA. And as with any situation where a BCE occurs, the scheme administrator must liaise with the member concerned, asking for sufficient information so that they can establish if a chargeable amount arises at the BCE. So it's clear communication is key here to ensure that enough has been done for the scheme administrator to be discharged of the liability for any LTA charge arising under the Finance Act 2004. The difficulties here, though, are exacerbated when dealing with revisiting BCEs, as it's likely to be more difficult to get the necessary information with the passage of time. Paying any tax charge due, well, any LTA tax charge arising in the member's lifetime is the joint responsibility of the member and the scheme, and consideration needs to be given as to how any tax charge will actually be paid. It's not as straightforward to deal with this issue when looking at benefits that came into payment many years previously and are only now being adjusted. And finally, just touching on the reporting requirements that schemes have to comply with. The scheme administrator must account for any charge due using the accounting for tax return, and that should be amended to reflect the updated amount since the original BCE. And of course, any event report will need to be amended if the value of events reported have changed, or the revision to benefits results in further reportable events. So just to sum up this section, where a scheme is at the start of its equalisation journey, or there's no pressing need for matters to be progressed quickly, and for example, where a pensioner population is small, it may be that these issues don't present any significant concerns. But where there are time pressures, for example, with a buyout exercise, and in particular where benefits are being converted, it may not be possible to carry out this exercise in as complete a way as schemes might wish to do so. And in situations like this, where there are practical difficulties, we'd recommend that advice is taken on dealing with the revisitation of past benefit valuations. And I'll now hand over to Juliet for some final thoughts.
Thanks, Jane. Yes, so I guess our observations as legal advisors are that initially, after the first Lloyd's judgment in October 2018, there seemed to be a kind of general panic, for want of a better word, about the cost of using a dual records methodology for equalising GMPs. And as such, back then, conversion, and particularly method D2, was kind of all the rage. But people didn't know back then the full extent of the tax issues that would arise. And I think also there was a general assumption that whatever the tax issues were, they were solvable, and that HMRC, the DWP, whoever would be able to assist with guidance and indeed potentially changes to legislation. In practice, however, as we've shown today, that's not been the case, and this has really fallen into a sort of too difficult bucket. As we've discussed today, the most tricky tax issues do arise in respect of conversion, and from what we've seen, that's particularly on the deferred member carve-out and on the lifetime allowance points. But as Jane indicated just at the start, there are also various other considerations that kind of have an impact if you opt for conversion. So just to be clear, these are not the only issues, they're just what we are saying are the main issues. The third issue that we focused on today, revisiting past benefit valuations, again, as Jane said, that applies regardless of whether you're using dual records or conversion. So I guess our key message, the kind of main reason that we were keen to focus on the tax points, was really just to emphasise the importance to properly plan for GMP equalisation. It probably seems quite obvious to many of you, but it is important to do that and to make sure that the plan has realistic timescales, particularly if you are thinking about conversion. And it may be the case that many schemes are now moving away from conversion as the solution, but we're not sure that that's quite the case yet. We definitely are seeing that more schemes are now saying that they're probably going to go for dual records, probably C2, but as I say, we're not seeing that complete shift yet away from conversion, in contrast to the situation, as I say, that we saw just after Lloyd's first came out. So I think, you know, just touching on a couple of the things that Maureen and Jane talked a bit about, on the deferred member carve-out, we as lawyers, along with our actuarial friends, can come up with solutions. And this is the kind of, again, key messaging. We can come up with solutions, and some of them are easier than others from a legal perspective. The problem is that none of them are risk-free. And that means that we can't give concise or indeed definitive non-caveated advice, because we don't have sufficient guidance or legislation to follow. And so the whole situation can end up quite unsatisfactory and challenging. As lawyers and as a team, we like to find solutions. And this is genuinely not a situation we like being in. Reflecting for a minute on the lifetime allowance protections, once you get an idea of how many members you have with some form of protection, as Maureen mentions, you have to assess and analyse these and make proposals potentially in respect of each one. So possibly different proposals for different categories of member. It's a difficult process. And we also talked about how there are ways to mitigate. One of the other things that we've seen is ideas where you actually get the members who've got protection to actively raise discrimination claims against trustees, with the idea being that the trustees and employer then settle those claims. But again, is that really something that you would want to do? How do you figure out, as Maureen kept saying, how do you quantify the risk or work out what the appropriate sum to settle at is? And generally, what additional time would going through a process like that add to your overall project plan? And how easy would it be to get the scheme's employer engaged with this? They may well be the ones proposing it, but none of this should be underestimated in our experience. It is definitely not an easy undertaking. And ultimately, choices like that, where you think about claims, will still not completely remove the risk. So our key points really are that we think schemes should, of course, be planning. If you're looking at doing conversion, look into finding more about that. And if you're an actuary, it's obvious again, but setting out the specific detail of each stage we think is important. We're not saying it's wrong at all, but I think everyone needs to understand the full approach. And if you are doing a buyout, push your insurer on whether they can move from conversion, because we are seeing that. The key point is no one size fits all. I possibly went on a bit too long there with my summing up, but we do have some time for some questions, and I can see some coming in. One of them is possibly inevitably that it's clear from what we've been saying that from a tax perspective, conversion is challenging. So why would schemes still want to go down that route at all? And this is something that we've seen before being asked. And I think it's probably just back to the points that conversion does make GMP go away, and it also allows greater member flexibility. So there's still these kind of options around possibly looking at benefit redesign projects which are not available with dual records. And it's not impossible to solve the tax issues. You know, it does very much depend on the scheme. And obviously the point that we've already touched on is the if you're in a buy-in, buy-out, and you've got particular proposals coming from your insurer, that makes things difficult too. So there can still be reasons from it, but it's obviously a fair question. Another point here is just asking whether it's possible to write to HMRC and ask if something that you're proposing to do would be okay. And in respect of that, you can write to HMRC about anything you want. I think what we'd probably say is that given the guidance that's come out from them so far, I don't think that we'd be particularly confident that HMRC would give any definitive view back in response to questions that you might want to ask. So I wouldn't be inclined to think that that would be something that would be kind of worthwhile to pursue. We are kind of over time now. People have asked questions around the judgment on Friday and the tax issues arising from that. Just kind of very quickly on that, obviously we all need to digest the judgment. I think the main tax issues will come from the specifics of you know, how you pay benefits back to members, but that is something that we as a team are looking at, and if anyone wants to follow up with us separately on that, we're happy to chat. I think I better draw things to a close today. As I say, we're very slightly over time, so thank you all very much today. Hope you enjoyed the session, and goodbye from all of us. Thank you.